Hello and welcome to Inside Policy Talks, the in-house podcast in the Macdonald-Laurier Institute. I'm Aaron Wudrick, the director of MLI's domestic policy program. Very pleased to be joined today by David Thomas, a lawyer and mediator based in British Columbia and the former chairperson of the Canadian Human Rights Tribunal. And he's here today to talk about his recent op-ed that appeared in the National Post regarding Bill C-63, the online harms app being proposed by the federal government. And his op-ed didn't mince any words. It's entitled, "I chaired the Human Rights Tribunal. It has no business policing hate speech." So, David, thanks so much for joining us today.
Thanks, Aaron, for having me. Really appreciate it.
So, I mean, maybe we can start with the obvious question. You were the chairperson of the Canadian Human Rights Tribunal for 7 years. Maybe talk a bit about your professional experience, what it was like being on the tribunal, and what you're up to today.
Well, it's quite an interesting experience for me. I was a part-time member of the Canadian Human Rights Tribunal here in British Columbia for a while, and then when the head job came open, I upended my law practice in Vancouver. Surprised a lot of people, disappointed a couple of teenagers that had to move to Ottawa with me, and went back there. And it was really an interesting experience coming from the private sector. I started my career as a business lawyer with a big law firm, and then I have my own boutique firm for about 20 years. And then, being thrust into the government in Ottawa was a shock unto itself. But it was an interesting experience being the head of an administrative tribunal like the CHRT. One of the things that people don't understand often is that administrative tribunals were created to be an expeditious way for people to have access to justice, which means that subject matter experts are appointed to these tribunals, and they're there to deal with things in theory much faster than the courts would normally deal with specific matters. Unfortunately, that's not the way it works out most of the time.
Yeah, well, we can circle back to that a little bit later on because interested to hear about the issue of expeditiousness in these tribunals. I mean, maybe we could turn to your op-ed. I mean, obviously, to have someone who served in the position you did to write a piece about a bill that is going to, empower these tribunals even further is, I think, raised a lot of eyebrows. So maybe you could talk about why you decided to write this op-ed and maybe just summarize what your big concerns are about Bill C-63.
Well, we have a dilemma here, right? We have a choice between tolerating words that we find offensive, or we implement a regime under Bill C-63, which is going to create a chilling effect on free speech in this country and robust political dialogue. So that's neither choice. Like, I'm not in favor of hate speech. I don't like it, but I have to choose between two undesirable things. And I think the less undesirable one is for us to tolerate speech that we don't like. We have a number of provisions in the criminal code already to address extreme hate speech, and we can get into a separate debate about whether the government applies those laws or does it on an equal basis. That's a separate debate. But the main problem with this legislation, and I think even with the previous legislation that we had under the old Section 13, is that the definition of hate speech, right, it's really often in the eyes of the beholder. Like, there's not a real clear objective definition. And this Bill C-63 has relied on the 2013 Supreme Court of Canada decision in Watcott. And it's taken the language out of that decision and tried to build a definition of hate speech, which I can read out to you, but it's not important. The real point is that it's not clear, and that where that line is, where hate speech begins and robust political discourse ends, it's not clear at all. Mm-hmm. So then it becomes really important. Like, if there's a certain amount of subjectivity involved in making that determination, then it's very important to think about, well, who are these people that are going to be making the decision? And you've got a regime now that proposed where the complaints will go into the Human Rights Commission. I want to be clear, the Commission is very different than the Human Rights Tribunal. They're separate, arm's-length, independent organizations. And the Commission has a broad mandate, not just to deal with complaints, but also to advocate for human rights and to educate and to be involved in international human rights affairs. The tribunal, on the other hand, is really a quasi-judicial court let's say. It's not a court, but it's like a court. It's a tribunal of decision makers. All of them, fortunately, are legally trained, although the Act does not require that all of them be legally trained. And it's this group that we entrust to be impartial, neutral, right, and somewhat expert in this area. And that raises a bunch of red flags right there when you just think about that. The other problem with this whole proposal is that anybody who's had experience with discrimination in the Human Rights Tribunal, and I would say probably for most of the provincial human rights tribunals as well, is that these things move through the process at a glacial pace, right? It takes years for things to move. So when I was the chairperson at the tribunal, I received every single complaint that the commission referred to us, and then I would delegate them to the different members or keep some of them for myself to adjudicate. It would be rare if a complaint came to the tribunal within around 1 year since it was filed. Normally it will be 2 years, sometimes 3 years before the complaint even made its way to the tribunal. And then, of course, the tribunal will often offer mediation. The parties get into a case management mode. If they don't do the mediation, they don't settle there. And often it's a year or longer before a hearing date can be set. And so by the time a decision is rendered by the adjudicator, it's easily 3, 4, 5 years. Sometimes, I'm sad to say, even longer. And that's where we'll go. And I would expect, in fact, a flood of these cases if it passes.
Yeah, so much for expeditious, although maybe by government standards, 3 or 4 years to resolve one of these matters counts as expeditious, which should be alarming to a lot of people. You just said a lot there that I want to unpack, but I want to come back to the issue of the subjectivity of hate, because I think a lot of the time, debates over what should and shouldn't be allowed comes down to debates over what are the limits on speech. I mean, we all agree that free speech should be robust. I don't think there are many free speech absolutists. I mean, we have well-established exceptions to free speech, things like incitement to violence, libel. But I guess the question is there any plausible way that you can treat a concept like hate? You take incitement to violence, for example. There's a pretty bright line there, right? Like if you're calling for or implying that someone should be physically harmed or assaulted or killed, that's incitement to violence. With hate, and you alluded to a lot of the language that's referred to, and whether it's the language in Whatcott, whether it's the language proposed in C63, a lot of it is comes down to nuances, but the difference between things like disdain and dislike. And is this the fundamental challenge with hate speech? Is that what counts as hate speech really is going to vary from person to person?
Absolutely. And there's a great example. I don't know if you've been following the case of Amy Ham here in British Columbia, but she's the nurse that posted a billboard a few years ago that said, "I love J.K. Rowling."
Oh,
and
yes.
Her discipline, the regulatory body for nurses, the discipline tribunal has taken her to task, and she's just finished an 18 or 19-day hearing on whether or not she should be disciplined for her personal opinions. And I understand that the college's council has argued that the billboard that said "I heart J.K. Rowling" is hate speech, right? So
right.
So if that's hate speech, I know that this surprises a lot of people, but in the view of others,
sure,
clearly to them that's hate speech. So I mean, this is the problem you get into, right? It's like,
yeah,
it really often depends on where people are coming from, and there's not a clear line, right?
Yeah. So, and for people who don't know, when you're talking about the billboard, the issue with J.K. Rowling being that she's the author of the Harry Potter books, and she had these views on gender identity and whether trans women are women, and so so the allegation is that because Amy Ham says she likes J.K. Rowling, J.K. Rowling has views on transgenderism, and that those views are interpreted as, some people argue, wanting to erase them. That sort of chain leads to some people arguing that it's hate speech, and it's as an example of why you can turn almost anything, if you sort of move enough steps removed, can be plausibly in their eyes argued as hate speech. So and this is a real case that is happening now. This isn't like a hypothetical. This is a live issue.
Absolutely. And and again, it boils down to do we want to tolerate things that we're not comfortable with, we don't like? I mean, really, that's what hate speech is all about, right? Is allowing the other people to say things you don't want to hear, not just allowing people to say things you don't mind listening to, right? I mean, the real test is when somebody says something you really disagree with, and that's the most important thing here. And I think that we should leave the criminal law alone. There are some good things there. There are some protections there to make sure it's not abused. And also, there's a different standard that the court would imply, which is beyond a reasonable doubt. That's another important thing to mention, is that in human rights, and it's on the balance of probabilities, right? And so it's a much lower threshold for a complaint to be substantiated before the tribunal. And when you've got such a vague definition, like, this is the thing that I fear the most, is that everybody will self-censor suddenly, right? People will kind of go, do I really want to be the respondent to a human rights complaint? Because, I'm going to have to deal with that. I might have to hire a lawyer. It's going to cost me money. This other regime, which, they're proposing about having a new commission and an ombudsperson, right? And the platforms that host things, I guess the big ones like Twitter or X and Facebook, they'll be subjected to potentially some very hefty penalties. They'll just recoil, I think. They'll just say, well, let's err on the side of caution, because it's going to take years for there to be a case that works its way through and then gets appealed up the courts. And so in the meantime, free speech in this country will be chilled, and people will be afraid to comment on things like, for example, immigration policy, right? It's a big topic right now. It's affecting lots of things for affordability for Canadians, that sort of thing. Is that going to be dangerous territory for people to have a debate about that now? I think that's the real fear that I have, is that people will self-censor while all this stuff is unfolding, and before we have any clarity as to where this is going to go. And it surprises me, because, the last Section 13 was unworkable. I mean, it's laughable how that played out, frankly. And, when it was originally, people forget that it was originally Keith Martin, who was a Liberal MP, that originally proposed a private member's bill. I think it was in 2008 to get rid of Section 13. And it didn't happen until, I think it was 2012, that another private member's bill came, and then Harper government decided it's time to put this thing to bed. And, and then the tribunal got to focus in on its core work, which was, discrimination against a prohibited ground under the Canadian Human Rights Act. The thing about this thing too, like, the proposal in Bill C-63 is to add 2 new members to the tribunal to deal with all these hate speech cases.
That'll cover it.
When I was there, like, a few years ago, like, this started, right? These proposals from the minister's office came to us in 2019, and then it came back in 2021, and they asked us to do some modeling exercises, like, how would this impact the tribunal? What kind of additional support would we need? What would the budget increase need to be? How many members would we need? And, I remember us saying we're going to need a lot of new members, maybe double the size of the tribunal. And yet they come out with a paltry 2 additional members. And I'd add that right now, the Act allows up to 18 members on this tribunal. There's only 11. This is the other thing, is the appointment process is super slow. I don't know why there's so many vacancies right now, but I know that it's creating a backlog in the discrimination cases. So this is the other thing on the ground, is like, you can say these things and say, oh, we're going to do this and we're going to do that, and this is how it's going to work. But whether it's going to work that way or not in practice is another thing. And I think, to be honest with you, I mean, we've seen a lot of big announcements and the big programs being announced, but not a lot of follow through. And I fear that will also complicate things for Bill C-63. And as I say, in the interim, right, could be years, people will self-censor, and they'll be afraid to say things or post things online, and Canada will be a different country.
It seems a little bit contradictory for them to claim on the one hand that this sort of epidemic of hate speech is so great that they need to bring in this bill, but that they can address it with just 2 new members on the tribunal. I mean, either it's a big problem or it isn't. And yet they seem, they seem unconcerned about how they were going to execute on this. Maybe we could talk a little bit about the difference between a court and a tribunal. I think a lot of people you essentially treat them as being analogous, maybe just a tribunal as just being a specialized court. But there are some differences in terms of the standards and the rules. So maybe, you know, as someone who's sat on the tribunal, you could sort of illustrate what some of those differences are.
It's a great question. And so first thing I'd like to say is that under the Canadian Human Rights Act, only the chairperson and the vice chairperson are required to be called to the bar of a province in this country or territory, called to the bar for at least 10 years. For all, and I think there's another provision that maybe 2 other members should be called to the bar. But other than that, there's no requirement in the Act that says those other members need to have any legal training whatsoever, right? And this, I think this is a throwback to when this act was created in 1977, and maybe they had it in mind that, you know, they'd have a hearing in the morning and then their decision would be rendered in the afternoon, and these things go super fast.
Yeah.
You need to be the experts on things. But the reality is that these human rights discrimination cases are super complex, and they go on for years, and we deal with all kinds of very complicated legal issues on the tribunal. And so the few times that I had the minister's ear, Minister Justice's ear in Ottawa, I mean, talking about reform to the Act, I always used to say, you need to change it so that every member on that tribunal has at least 10 years called to the bar, because it's the kind of job that, you know, you need some depth of experience to do, right? And so that's the first thing that I think is very important. The second thing is that the rules of evidence are relaxed in a tribunal as well. So we're allowed to admit things into court that possibly would not, into the tribunal hearing that would not be permissible in court, you know, like hearsay documents or other things that might be objectionable in a court of law. We've got flexibility under the Canadian Human Rights Act to admit that evidence. So that's another important fact. And the other thing that I said before, which is that the standard that we're deciding these cases on is a balance of probabilities. So again, it's a lower threshold particularly in discrimination cases. You know, there's some case law that says we're looking for the subtle scent of discrimination, which is enough to justify a finding of discrimination. So it could be a very low threshold, right? Somebody's adverse differential treatment, you know, it doesn't need to be wholly because of discrimination, but if it's partially because of discrimination, then it's going to be substantiated, and there'll be remedies and consequences for that.
Could you talk a bit about the ability of complainants to be anonymous? I understand there's some provision under the existing rules, but what's proposed in C63 would make it easier to potentially be anonymous as a complainant before the tribunal.
That's exactly right. So you know, under the way the tribunal works now, there's a presumption of public record transparency, that everything is presumptively open to the public, and so people can request, you know, copies of documents that have been submitted in support of a case, statements of particulars, that sort of thing. There is a section of the Act that does allow a member to anonymize some names. Sometimes it's the witness, sometimes it might be the complainant, but there's criteria there that have to be met, and it's usually a reason that it'll create a prejudice to the other parties if there's a disclosure, or there'll be some harm, life, liberty, and security to a person. I mean, there has to be a reason, right? Now, interesting in B63, and it tells you something, that they've carved out a lower threshold just for hate speech cases, right? So if I remember right, the language is if you're suspect that you'll be subjected to threats, threat, discrimination, and but it's a lower threshold, and that makes me concerned that, you know, that people will bring these allegations and then try to invoke the cloak of anonymity behind it, and I think that's also problematic.
Right. I guess we're nearing the end here, but I wanted to ask if you think, you know, C63 is wrong-headed, and this comes back to what you said earlier on about, I don't think anybody really, like, no one wants to stand up and say, I love hate speech. Hate speech is, I mean, it's unpleasant. It doesn't feel nice. A lot of people are put off by it. It can be uncomfortable. You know, it can hurt your feelings. But But is there anything else that could be done? If not C63, are there other tools that you think the government could consider? Are there existing tools they're not using? Or is this a matter of society having to accept that one of the prices we pay to having robust free expression is that we do have to tolerate a certain level of what some people call hate speech, because there's no other way to ensure that people are going to be free to speak their minds?
I think the answer to hate speech or speech that we find offensive is more speech. It's not censorship, right? We need to have a free marketplace of ideas and put the truth out there. And the good ideas will rise to the top and the lousy ideas will get pushed to the bottom, right? And that's, I think, the answer here. And I think that, Aaron, one of the things that I see myself, sometimes I look at the mainstream media and I look at the self-censorship that goes on within those big networks that I don't think was there maybe a generation ago. And it feels like sometimes they're hiding the truth. And the truth is always the most important thing that we should try to strive for. And to get to the truth means we need to have a free marketplace of ideas. And the last thing we need in that marketplace is censorship, or people trying to, put their thumb on the scale and trying to push something one way or another. I think that bad ideas will get pushed down if people feel free to express themselves and to have a free, open marketplace of ideas. And that's really the key to suppressing very bad ideas that are out there.
Well, I think we probably see eye to eye on that, David. I'm a big fan of responding to bad and troubling speech with more speech. I think that is always the way. You don't have to let it go. People say, should we? You're saying we should do nothing? Absolutely not. We should respond, and we should speak truth and be unafraid to counter things that we find problematic. So anyway, this has been fantastic. Thank you very much for joining us today. Thank you so much for writing this piece and getting your opinion out there. I think you speak with great authority on this issue. And thank you to our listeners and viewers. We'll see you next time on Inside Policy Talks.
Thanks, Aaron.